Hello, everyone. Welcome to the series of Public International Law. My name is Bisna Awan, and today we'll be discussing the prohibition of torture and ill treatment under the international law. The prohibition against torture in international law is like that against slavery or genocide. That means it is absolute. Torture is impermissible under any circumstances, including war, public emergency, or terrorist threat. The prohibition is so strong and universally accepted that it is now a fundamental principle of customary international law as well. This means that even states which have not ratified any of the international treaties explicitly prohibiting torture are banned from using it against anyone, anywhere in the world. The prohibition of torture and other forms of ill treatment derives from the following instruments, which include the Geneva Conventions of 1949, the Additional Protocols of 1977, the Convention Against Torture of 1984, and other international instruments. The prohibition of certain forms of ill treatment is central to every treaty relating to the civil and political rights. Not only that, it is always one of the first substantive rights protected in each such treaty. Each treaty states that the right cannot be derogated from at time of emergency, nor do any of the treaties permit limitations to the prohibition. As the fundamental idea of human rights clearly implies that torture is unacceptable. So the inherent dignity of the human person is the foundation of that prohibition, but there are also other sources that support this general principle. Moving on to the definition of torture and other forms of ill treatment. Now, under the international humanitarian law and international human rights law, the definition of torture basically comprises of three main aspects, which includes any act by which severe pain or suffering is inflicted on a person, whether be it physical or mental. Secondly, the act must be intentionally inflicted upon that person. Thirdly, the act must be instrumental for such purposes as mentioned, which include obtaining from the individual or a third person information or a confession, or punishing him or her for an act he, she, or a third person has committed or is suspected of having committed, or intimidating him or her or a third person, or coercing him or her or a third person, or for any reason based on discrimination of any kind. What distinguishes torture from other forms of ill treatment, which include other cruel, inhuman, or degrading treatment and outrages upon personal dignity, is basically the third aspect. The inhuman and cruel treatment is defined as the infliction of the severe physical or mental pain or suffering which goes beyond mere degradation or humiliation. And the outrages upon the personal dignity are the acts that humiliate, degrade, or otherwise violate the dignity of the person to such a degree as to be generally recognized as an outrage upon the personal dignity of a person. Unlike torture, there is no requirement that these acts be inflicted for a specific purpose. International humanitarian law applies to all parties to an armed conflict. In contrast to the international human rights law, treaties, including the 1984 Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, apply exclusively to states, as the Article 1 of the Convention Against Torture contains the additional requirement that the prohibited acts be inflicted by or at the instigation of or with the consent or acquiescence of a public official or other person acting in an official capacity. Now, moving on to the key international instruments. Under the international humanitarian law, we have the following instruments regarding the prohibition of torture and other forms of ill treatment. These instruments include the Hague Regulations respecting the laws and customs of war on land, the four Geneva Conventions of 1949, and their additional protocols. Furthermore, we have the Rome Statute of 1998 of the ICC, which deems torture and other inhuman treatment to be war crimes in both international and non-international armed conflicts. Next, we have is the Rule 90 of the ICRC study on the customary international humanitarian law. This rule establishes that the prohibition on torture, cruel, or inhuman treatment and outrages upon personal dignity, in particular, humiliating and degrading treatment in both international and non international armed conflict, is a norm of customary international law, whereas the Rule 156 of the ICRC study provides that the serious violations of the international humanitarian law include the torture and other inhuman treatment, and these constitute as war crimes in both the international and non-international armed conflicts. Whereas under the international human rights law, we have the prohibition on torture, which is enshrined in the international human rights instruments, and these instruments include the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the Convention Against Torture. Furthermore, the prohibition on torture is also contained in the regional human rights instruments, such as the 1950 European Convention for the Protection of Human Rights and Fundamental Freedoms, the 1969 American Convention on Human Rights, the African Charter on Human and People's Rights, the European Convention for the Prevention of Torture, and others. Now, we will be looking at the legal obligations that are derived from the prohibition of torture and other forms of ill treatment under the international law. The legal obligations comprise of the following. They include enacting criminal sanctions, jurisdiction over acts of torture, prosecuting alleged offenders, non-refoulement, non-use of information obtained from torture, and remedies and reparation. We will be discussing each of them in detail under the perspective of the international human rights law and under the international humanitarian law. First one is enacting criminal sanctions. Now, under the international humanitarian law, torture and other forms of ill treatment are grave breaches of the Geneva Conventions and their additional protocols, as well as being serious violations of the international humanitarian law and war crimes in both international and non international armed conflicts. And the relevant provisions include the articles of the four Geneva Conventions and the articles of the additional protocols, including the articles of the ICC statute and ICRC study on the customary IHL. And states have a duty to enact legislation prohibiting acts of torture and other forms of ill treatment and punishing those who commit them or order them to be committed. Individuals can be held criminally responsible for committing these war crimes. Furthermore, the military commanders are required to prevent, repress, or even take action against those under their control who commit such acts of torture and other forms of ill treatment, and these protections are listed under the articles of the four Geneva Conventions, their additional protocols, and the rules of the ICRC study on the customary IHL. And to give effect to the principle of complementarity, the state parties to the ICC statute must adopt domestic legislation to incorporate all crimes under the statute, including the crime of torture. Whereas under the international human rights law, we have the Convention Against Torture, which states and obliges all state parties to ensure that all acts of torture are offenses under their criminal law, including attempts to commit torture as well as acts by any person that constitute complicity or participation in torture. Furthermore, the state parties are also required to make these offenses punishable by appropriate penalties that take into account their grave nature. The next legal obligation is the jurisdiction over acts of torture. Under the international humanitarian law, states are required, under the Geneva Conventions and the Additional Protocol 1, to exercise the universal jurisdiction over grave breaches which include acts of torture and other forms of ill treatment and that are committed during the international armed conflicts. Thus, the states have an obligation to search for and prosecute alleged perpetrators regardless of their nationality and of where the act was committed. As per the Rule 157 of the ICRC study on the customary international humanitarian law, the states also have a right to vest universal jurisdiction in their national courts for war crimes, including torture and other forms of ill treatment committed in non international armed conflicts. Whereas under the international human rights law, we see that the Convention Against Torture states that the parties must establish jurisdiction over acts of torture where the offenses are committed in any territory under their respective jurisdiction or where the alleged offender or the victim is a national of the state. Furthermore, this Convention Against Torture also specifies that a state can also establish universal jurisdiction over the crime of torture where the offender is present in any territory under its jurisdiction, and these provisions are in keeping with the underlying object and purpose of the convention, which has been stated in its preamble as well, that is, to make more effective struggle against torture and other cruel, inhuman, or degrading treatment or punishment throughout the world. Next legal obligation that derives is the prosecuting or extraditing alleged offenders. Under the international humanitarian law, states have an obligation to search for persons alleged to have committed or to have ordered to be committed such grave breaches and to bring such persons, regardless of their nationality, before the state's own courts if such persons are not extradited to another state. And all these are reflected in the articles of the Geneva Conventions and their additional protocols. Whereas under the international human rights law, we have the Convention Against Torture stating that the states are required to prosecute the alleged perpetrators of the offense of torture in any territory within their jurisdiction if such persons are not extradited to another state. Whereas another article of this convention states that states must make torture, including complicity or participation, an extraditable offense in any extradition treaty between the state parties. Furthermore, where states make extradition conditional upon the existence of an extradition treaty, then the Convention Against Torture may serve as a legal basis for extradition if a state does not have an extradition treaty within the requesting state. Next is the non-refoulement. Now, the Convention Against Torture provides that no state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. Furthermore, this convention also states that for the purposes of determining whether there are such grounds, the competent authorities shall take into account all relevant considerations, including, where applicable, the existence in the state concerned of a consistent pattern of gross, flagrant, or mass violations of human rights. Next we have is the non-use of information that has been obtained from the torture. Now, as per the Convention Against Torture, the Article 15 of this convention provides that any statement that has been made as a result of such torture shall not be invoked or used as evidence in any proceeding except against a person who has been accused of torture as evidence that the statement was made. All the essential judicial guarantees must be provided to ensure that the accused persons receive a fair trial, and this has been mentioned in the articles of the Geneva Conventions and their additional protocols. Next, we have are the remedies and reparation under the international humanitarian law and under the international human rights law. As per the IHL and the Article 91 of the additional protocol 1, as reflected in the rules of 149 and 150 of the ICRC study on the customary IHL, requires that a party to the conflict that violates the provisions of the convention or of the protocol shall be liable to pay compensation, which by reference includes torture and other forms of ill treatment. Hence, it shall be responsible for all acts that have been committed by persons forming part of its armed forces, whereas We can see that in international human rights law, similarly, the Article 14 of the Convention Against Torture provides that each state party has to ensure in its legal system that the victim of an act of torture can obtain redress and has an enforceable right to fair and adequate compensation, including the means for as full rehabilitation as possible. Furthermore, the dependents of the deceased victims of torture are likewise entitled to be compensated. Next, we have is the monitoring and reporting mechanisms. Now, under the international human rights law, to ensure the effective implementation of the prohibition on committing torture and other forms of ill treatment, a number of independent mechanisms are provided for under the international human rights law. And these include the national preventive mechanisms, the Committee Against Torture, and the Subcommittee on Prevention of Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. And the members of these bodies should be of high moral character with proven professional experience in the administration of justice, in particular, criminal law, prison or police administration, or in other fields related to the treatment of persons deprived of their liberty. The members shall serve in their individual capacity, be independent and impartial, and shall be available to serve the mechanisms efficiently. Furthermore, the Article 19 of the Convention Against Torture also requires states to submit reports on the measures they have taken to give effect to their obligations under the Convention. Moreover, the Article 13 of the Convention Against Torture states that any individual who alleges that he has been subjected to torture in any territory under a state's jurisdiction has the right to have his case promptly and impartially examined by the state's competent authorities. Whereas, in, under the international humanitarian law, through the Geneva Conventions of 1949, the international community has mandated that the ICRC to visit both prisoners of war and civilians interned during the international armed conflicts. The ICRC assesses the physical and mental well-being of the detainees through visits to places of detention, dialogue with the detaining authorities, and private interviews with the detainees themselves. All of this helps to ensure that the detainees' treatment and conditions of detention meet the international humanitarian law and internationally recognized human rights standards. Furthermore, the ICRC uses the information collected from detention visits to engage in confidential dialogue with the authorities. Among other things, it strives to prevent torture and other forms of ill treatment. Last but not the least, we have is the prevention of torture and other forms of ill treatment. Under the international human rights law, the Article 10 of the Convention Against Torture requires the state parties to ensure that education and information regarding the prohibition against torture and other forms of ill treatment are fully included in the training of law enforcement personnel, civil or military medical personnel, public officials, and other persons who may be involved in the custody, interrogation, or treatment of any individual that has been subjected to any form of arrest, detention, or imprisonment. Furthermore, another article states that the parties are required to keep under systematic review interrogation rules, instructions, methods, and practices, as well as arrangements for the custody and treatment of persons subjected to any form of arrest, detention, or imprisonment in any territory under their jurisdiction with a view to preventing any cases of torture. Whereas under the international humanitarian law, we can see that the Geneva Conventions require that the state parties disseminate as widely as possible in their respective countries the text of the Geneva Conventions in times of peace as in times of war. And these texts refer to the prohibition of torture and other forms of ill treatment. They have been stipulated under the articles of the four Geneva Conventions, as well as their additional protocols, where the state parties are obliged to include the Geneva Conventions and military instructions as well. Concluding this, I would like to state that Under the international law, both international humanitarian law and the international human rights law converge and complement each other in establishing a comprehensive legal framework for the prevention and punishments of acts of torture and other forms of ill treatment. There is an absolute ban on torture and other cruel, inhuman, or degrading treatment and outrages upon the personal dignity under the international humanitarian law and international human rights law. Thank you.